communist Russia. Mr. Williams is having the worst trial.
Oh, man. Welcome back to Law and Crime. That was Brian Steele, the attorney for Atlanta rapper Jeffrey Williams, also known as Young Thug. The rapper, along with 5 co-defendants, charged with a slew of gang-related crimes connected to the alleged street gang YSL, short for Young Slime Life. Those crimes range from drug distribution and firearm possession to armed robbery, murder. On the other side, the defense says, no. YSL is actually just a record label called Young Stoner Life, with themes surrounding tough life circumstances. A lot has happened this week, I'm telling you, but before we bring you more of the drama, let's play some catch-up here. Brian Steele back in action after the Georgia Supreme Court granted him a supersedeas bond so he could appeal his contempt ruling by Judge Glanville without going to jail. This all stems from the argument on Monday when Steele confronted his judge about an ex parte meeting involving the state's witness, remember Lil Woody, Kenneth Copeland? This happened during a private conversation involving the judge and prosecutors and Copeland, allegedly Copeland admitting that he killed YSL gang rival Donovan Thomas Jr. Now, before this, Copeland, who is, by the way, a convicted felon anyway, had finally agreed to testify. Remember, he took the Fifth some time ago. He was arrested last Friday for invoking his Fifth Amendment right in front of the jury, and 5 days on the stand has led Copeland to admit that he lied to police and to the jury in this trial. But other than that, everything's perfect. Anyway, that all has to do with his involvement or lack of involvement in the YSL street gang. All of this to protect his innocence. Now, earlier in the week, Copeland also fired his attorney, Kayla Bumpus. Now, she was going to have to go to a show cause hearing, which is normal in this case. That was going to happen on June 25th. But Copeland will continue to testify without counsel for the time being. This is a mess. So, now you're up to speed. Let's take a look at the latest drama. This unfolded Thursday. Before court went to lunch, Brian Steele went at it with the judge and the prosecutors once again, this time about witness intimidation surrounding Copeland. Check it out.
I would like the court to look into the appropriateness. Mr. Copeland, to my observations around your courtroom, outside your courtroom on breaks, is surrounded by several members of law enforcement with the district attorney's office and prosecutors, potentially other persons. I don't know why a sitting witness under oath is in a room with prosecutors during breaks, mornings, afternoons. It's totally inappropriate. There are people who are in your court's door. There's a double door where the court sits to its right that aligns with the witness chair. And I noticed people standing there in law enforcement while Mr. Copeland is testifying. He's making eye contact with them. I don't know if they're his brother. My point to you is this: what gives anybody the right to surround a witness? He's not in custody. And bring a witness. I'm sure Mr. Copeland didn't say to the prosecutors, I don't know this, Your Honor, so if you think I'm wrong, then just strike it from your memory. But I'm sure he didn't say, hey, you guys want to hang out in this room a little while? So I believe that he is being led on a tether by the prosecutors, and it is coercion. It is inappropriate. And why would anybody not be recording everything he said? And why do I have to get it in drips and drabs? So I am objecting to the tactics of the Fulton County District Attorney's Office and whomever else they may have employed with a citizen, regardless of what the court may think of him or the prosecutors think of him.
I don't have any thoughts. So please don't put that in. Please don't put that in in the ether. Okay, but that's what you just said, sir.
The ether is clear. The court wouldn't do it. I wouldn't do it either. So why is it happening? He's a.
See, I have no interest other than I'm a referee.
Well, you're the referee who spoke with with the witness without my presence. So
Mr. Steele, we're not gonna get into that right now.
Well,
okay?
my point is, how is he being treated here? And why don't I have all this? And why is this going on? What an unfair trial for Mr. Williams. Think about it. If you were accused, Your Honor, and the judge met with this witness, with the prosecutor, and you sat next to me and Mr. Adams, you would say to us, what kind of case is this? Now he's being surrounded with all this law enforcement. My point is,
Your Honor, we're going to object that this.
I'm not going to be interrupted.
Mr. Steele, hold on. No, but you're Mr. Steele? Mr. Steele?
Yes, sir. What?
Okay.
I want to finish. I'm making a record for the court to understand.
Well, Mr. Steele.
I've never been interrupted in a court except for this one. You allow.
Well, you know, but the challenge is in this point in time is that some of the things that you have said at certain points in time are not appropriate.
It's not true.
Okay, well that's the court's. The
court is wrong. This is crazy. This is like communist Russia. Mr. Williams is having the worst trial. So I'm moving again to stop intimidating the witness by the prosecution, leave people alone, and stop accusing. You've allowed the prosecutor Love to accuse me of misconduct.
Oh, but you've also accused her of hold on. You have accused her of misconduct as well. And remember what I told you about your professional response. Remember what I told you about your. And she's gonna take me down as opposed to you. So when I start talking, stop talking, please. Okay? I'll let you complete your record. Okay?
I understand the one party talking. I got it.
All right. Okay. All right. So I told you, several times before, I told you and your colleagues, remember your professional responsibility. And let's not make this an ad hominem issue. I don't believe that either one of you are trying to do anything that would subvert your ability to practice law. But
Ms. Love has intentionally lied to the court numerous occasions. You do not.
Hold on. Let him finish. See, this is Mr. Steele. This is exactly what I'm saying. You cannot. It is not a good idea to state that your brethren across the bar are lying. Okay, in any time or any way.
I don't like doing it.
Okay, but don't. So don't. But don't because you don't because you don't have any proof. If you have proof of it, then if you have proof, there's a mechanism in law and under the rules for you to submit that question to the Office of General Counsel and for the investigation to occur. But please stop, both of you. I've told both of you earlier, stop making these ad hominem attacks toward one another.
I'm out of order. You're out of order. This whole courtroom is out of order. Thank you, Al Pacino and Injustice for All. Okay, so to back up Steele's claims of this witness intimidation, get ready for this. There were a couple of other attorneys mentioning their concern for a spectator that they'd seen near the courtroom.
I just want to put on the record that based upon my vantage point in the courtroom, I have a unique place where I'm able to see the jury, I'm able to see the witness, and I'm also able to see to the vestibule out here. And on yesterday, I just want to be clear that it's not only observed back here, but I have a unique place, and I observe a very large individual standing outside of that door, those two doors, staring at the witness during his testimony.
I noticed a large individual too. There's plenty of large individuals. They're law enforcement, or we don't know, but
I know it's law enforcement.
Well, who is it? What's their name?
I don't know his name.
Okay, well then we don't know it's law enforcement. But I have the same or better vantage. I have the same or better vantage than you do, and I certainly think that for reasons that we don't know that law enforcement stand in that door for security posture, and that's the only reason that they're at that door.
Well, I understand. I'm just putting on the record.
Okay. Well, when this is reviewed, and the court's going to look at what the court saw as well. So if you're thinking that there's intimidation or otherwise, I'm telling you, and I'm putting on the record for purposes of the record that there are many law enforcement that sit in both doors of this courtroom for that reason and that reason only. And unless you can tell me who specifically was standing out there as you say, and Mr. Steele said, looking at our witness, Mr. Copeland, then I don't see that. Okay? Thank you, sir.
Thank you, Judge.
All right.
Briefly, Your Honor, since no one wants to go to lunch more than me, I saw the same thing that Mr. Matthews saw yesterday with a large individual.
How did you see him? Your back's to the door.
Are you questioning whether I saw him or not?
I'm asking how you saw
I
it.
pivoted around and saw him.
Okay.
Because,
All right.
And because that we've seen people outside that door for 18 months, Your Honor. This person yesterday was glaring through that glass for at least 10 to 15 minutes that I noticed, boring a hole into the witness. So I just want to add that is what I saw. I don't know his name. I don't know if it was law enforcement. I believe it was. I have not seen any other individual with law enforcement do that to that witness or any other witness during the course of the trial.
Okay.
Thank you.
Thank you.
Just so that the record is clear, could they give more detail? Because there's no member of the state that fits that.
Yeah, I don't need. He was
no
a
idea
gentleman
what
yesterday
that was.
dressed in black or dark clothing. That's what I saw.
Also, yes, Your Honor, and I don't know. We don't know who they're talking about, what they're talking about. Literally no idea. So the idea, this insertion into the record of the insinuation that someone is intimidating anyone.
I'll also ask Captain Kendall to ensure that only law enforcement are allowed back there in the vestibule, so that that if there's any issue with anybody looking in the courtroom, that is removed. So, all right.
Thank you.
All right.
Okay, what's this case about again? I seem to have forgotten because there's a lot going on that has nothing to do with the case, generally. Okay, so let's talk to Catherine Lizardo and my new guest who's intimidating me here in the set. Dave Ehrenberg is here. He is a state attorney in Florida. Catherine, because I've left you alone for a while, I want to go to you on this. There are so many collateral issues in this case. The jury, they're sitting on their hands as much time as they're in the box. Where are we going with this case? I mean, it's 8 months in and there's no end in sight. I don't know. I'm just frustrated.
I feel the same with you, and I'm sure the jury feels 10 times more because they're the ones there waiting. When this is all happening, it's outside the presence of the jury. So they come to court, and then now they have to leave the courtroom, and they're wasting their time, and they've been here for so long. So these kind of things have to be resolved professionally. That's why the judge is saying, please keep in mind your professional responsibility. Be professional. And I was anticipating you'd ask me to be a professor about the ad hominems that the judge was talking about. He's basically emphasizing that the parties do not point at the person. Instead, keep their position in mind. Don't attack the person, but focus on what the valid argument is. Because right now, they're making it more personal than legal.
Yeah, the personalities involved are amazing. Okay, I always like to find a teaching moment here, Dave Ehrenberg. We're going to open up the Law&Crime classroom, and I'm not even going to bother Professor Lizardo on this one. Criminal contempt versus civil contempt. There's been no real discussion about it. We've heard a lot about contempt, and I think people just think of those, hey, you won't answer these questions, you're under subpoena, you won't produce these documents, you're under subpoena, you're going to go sit in the cooler until you figure out what you want to or can do. That's not the kind of contempt that's been argued here against Attorney Steele. It's a criminal contempt. Mm-hmm. And I mentioned the Al Pacino movie and Justice for All. This whole courtroom's out of order. That leads to criminal contempt. That's where you're not required to produce documents, you're not required to be somewhere and give testimony, but you're disrespecting the process or you're committing a crime in the context of the process. Do I have it right here? And the important difference in this case is, if you've got a penalty that could stretch into months, you get a jury trial for that kind of contempt. And I don't think the distinction has been made that clear. And I probably haven't helped. But what do you think?
No, in Florida, we had a case like this, and the guy faced up to 5 months, 29 days. That's the max for your criminal contempt.
So you can avoid the jury trial that way. Yeah.
Right? Yeah, very good. But here you've got disrespect to the court, and you've got the court who really threw the book at Steele. I mean, I was surprised that he went that far. And the appellate court seemed to agree. That's why they stayed it. There's a little insinuation that they're going to do something about this. So I'd be surprised if he actually had to serve the 20 days, 10 weekends in jail. This whole thing's become a clown show. I tell you, I mean, 10 months for jury selection alone. When that happens, you know things are problematic. You know, it's a circus tent there. So hopefully they can get on track, because what are we doing here?
Yeah, I mean, originally there were even more defendants. So, okay, maybe they've each got their own challenges, so that stretches the process. But it's the judge. I mean, you know, we've seen more recently the judge is either controlling or not controlling what's going on. But that's true during voir dire, and that's true during the selection process. It's his problem. He's got to fix it. And 10 months to get a jury, what can he do, if anything, to fix it at this point?
Oh, he's trying to take control of the courtroom by throwing a lawyer in jail. He threw the guy Copeland, one of the key witnesses, in jail. It's hard to control it when you have a witness get on the stand and say, I'm so high right now, I don't even know what's going on. Another person who says, yeah, I was given immunity and I'm still taking the fifth. So there's only so much a judge can do. He's trying to keep control of the courtroom and has been criticized for it. I don't know what else you can do. It's just in the nature of when you have all these defendants in a complex RICO trial involving some very interesting defendants who have
and
very
that's a novel
lives.
theory. It's a novel theory to try and lump all these prior acts into the RICO statute. So, it was almost destined to be a problem. Maybe not as big as the problems we've seen, but a problem. And by the way, Copeland, that was civil contempt, because he was there to give testimony. He refused. That's civil contempt.
Still thrown in jail, though.
Yes, that's why it gets confusing. How could it be civil contempt? It's a criminal matter and you can go to jail. But that's the distinction.
What's so civil about war anyways? It's a Guns N' Roses line.
Thank you so much for that. Let me make a note of that one. Okay, we're going to take a break. We're going to come back, and Karen Reed lurking. We'll go back to Massachusetts for more on that case right after this break. Stay with you.